we'll go ahead and get started. Clerk, call the roll.
Mr. Cadillac,
Here.
Mr. Stringer, Mr. Jackson,
Here.
Mr. Betzold, Mr. Bolton, Mr. Ingram, Mr. Estes, Ms. Fielder, Mr. Gray, Mr. Harbison, Ms. Morris, here, Mr. Pettis, Ms. Shaver,
Here.
Mr. Starn, Mr. Wadsworth. Quorum is present.
Thank you, Clerk. Representative Jackson, you open us up in prayer before we get started?
Thank you. Father, we know that you said all things work together for the good of those that love the Lord and those who will call according to your purpose. We come this morning to say thank you for your calling us into life this morning. As we laid down last evening, you awaken us to see the beauty of this day. Ask your blessing upon each and every one that's in the room. Bless our nation. Bless the leadership of this state. Bless our caucus chair, our chairman. And we ask you to bless and keep us in Jesus' name. Amen.
Amen. All right, we've got a special presentation today. They tried to get on the schedule last year. The session kind of ran out. So with that, from Voices for Alabama Children, is Rhonda Mann here?
Yes,
You have the mic.
thank you so much. Mr. Chairman, members of the committee, I would like to thank you for allowing us to come today and share with you information on child passenger safety. Voices for Alabama's Children and the Alabama chapter of the American Academy of Pediatrics, along with Children First, Children's of Alabama, the Alabama Department of Public Health, and Safe Kids Alabama, have come together to gather information and data and share updated facts about child passenger safety for your information and consideration. There's strong evidence that child safety seat laws are effective in increasing child safety seat usage. When appropriate, car safety seats are used as determined by manufacturers and based on age, weight, and height of the child, and when they are installed correctly, children 1 to 14 years of age have a better chance of surviving an automobile crash with fewer injuries or fatalities. Today, you'll hear from two speakers. I have Dr. Casey Smola, is a member of the Alabama chapter, American Academy of Pediatrics, and a pediatrician and hospitalist at Children's of Alabama. She'll share information about child passenger safety recommendations and what her colleagues in the emergency department are seeing related to injuries from automobile accidents. Our second speaker is Dr. Sherry Davidson. She's a state epidemiologist with the Alabama Department of Public Health. She'll share data on motor vehicle injuries in Alabama. At this time, I'll turn it over to Dr. Smola.
Good morning. I am Cassie Smola, and like she said, I'm a pediatrician in the Birmingham area. I work at Children's Hospital, where I take care of patients admitted to the hospital. I manage a wide variety of routine childhood illnesses, from pneumonia to dehydration to infants with fever. Unfortunately, I also treat children who have suffered injuries due to improper restraints in motor vehicle collisions. We see injuries that range from broken bones to brain bleeds to spinal cord injuries that leave some children needing ventilators, wheelchairs, or mentally impaired for the rest of their lives. Proper car seat use is crucial in saving children's lives. Repeated studies consistently demonstrate that the longer we can keep kids in car seats, booster seats, and proper use of seatbelts, the lower the risk of injuries these children face. Parents and pediatricians share the excitement of witnessing children achieve developmental milestones such as learning to walk, talk, or taking their first bite of food. Similarly, we need the same enthusiasm for car seats milestones, but the gradual progression through these milestones. The longer children remain rear-facing or stay in a car seat, the safer they will be in any motor vehicle accident. In my 14 years of experience as a pediatrician, I have witnessed the entire spectrum of injuries related to motor vehicle collisions. I have admitted children overnight for observation after a severe car crash, where often these children who were properly restrained did not require any surgeries or medical interventions. Conversely, I have also admitted children that have had brain bleeds, paralysis, internal bleeding, and broken bones. I have frantically assisted preparing a child to go to the operating room, hoping a neurosurgeon could stop the bleeding in their brain and save their life. I have cried with families over these losses, and I have celebrated with families who have successfully had children learn to walk again, talk again, or the victory of even being able to eat a small bite of food. I would now like to share a story of a patient I cared for just last week, a joyful 15-month-old who was learning to walk and loved eating. He was secured in a front-facing car seat, buckled in the back seat, when his family experienced a high-speed front-end collision. Unfortunately, there were multiple injuries to every family member in this vehicle, including this cheerful 15-month-old, who then suffered a broken leg, multiple skull fractures, and a brain bleed. He was emergently brought to the nearest hospital and subsequently then transferred to ours. Fortunately, after repeat imaging, it was determined that the bleeding had ceased, his skull fractures were stable, and his spinal cord was intact, eliminating the need for any surgery. His broken leg was casted, and we observed him in the hospital that night. He was then noted to have seizures that required seizure medication for them to be stopped, that he will likely need to remain on for months. We continued to monitor him for several days to ensure he could eat safely, his seizures had truly stopped, and his pain was well controlled. In many aspects, he was very fortunate. However, I strongly believe that if he had been rear-facing, all of his injuries would have been prevented. Car seats are effective. Manufacturers are consistently improving designs to allow children to stay rear-facing for longer and remain in a car seat until they are tall enough that a seatbelt poses less risk for them. Even with these advancements, motor vehicle collisions continue to occur and remain a leading cause of injury for our children in Alabama. Therefore, I strongly encourage this committee to review Representative Bolton's bill and approve it, to ensure that more of our children in Alabama grow up to have a bright future. Thank you.
Thank you.
Good morning. I'm Sherry Davidson, state epidemiologist. So we all know that child restraint regulations save lives. The data show that car seat use reduces the risk of injury and crashes 71 to 82% for children compared with seatbelt use alone. Booster seat use compared to seatbelt use alone reduces the risk of serious injury by 45% for children. Even small changes in regulations can have substantial impact. One study showed that by just raising the booster age by 12 months, so 1 year of age, from 7 years old to 8 years old, decreased incapacitating injuries and deaths by 17%. For the best possible protection, the Centers for Disease Control and Prevention recommends keeping children properly buckled in the back seat through 12 years of age. Airbags can kill young children riding in the front seat. We looked at the number of emergency department visits in Alabama for children less than 13 years of age who were injured in motor vehicle collisions. In 2023, there were over 5,000 children injured, requiring emergency care. Those injuries ranged from mild to life-altering. 17 children died. In public health, we often rely on numbers or statistics for data-driven decisions. But isn't one child or infant injured or killed one too many? If we have the evidence and information to know better and do better. Thank you.
Over the last 5 years, nearly 18,000 citations have been written for improper or incorrect child passenger safety. That's a potential of 18,000 children that could be seriously injured or even killed because parents weren't using the correct child passenger safety. Our goal is to limit preventable deaths and injuries and make it safer for children when riding in an automobile. Again, when the laws increase, information is put out there to educate parents better, and usage goes up when laws are put in place. Those of us today have had the privilege of working with Representative Bolton on HB 265, and we would encourage you to give it a favorable report out of committee. If you have questions for us at this time, we would be glad to entertain those.
Well, I have a comment. First of all, thank you for being here. Thank you for bringing folks up and bringing attention to this important issue. I've lost family members tragically, including a daughter in vehicle wrecks. But I have a good story. It happened a few years ago. My daughter, who's a registered nurse, had a 2-week-old, a 3-year-old, and a 6-year-old, my 3 grandbabies, in a vehicle, properly strapped in. A car came over into their lane, hit them head on, totaled both cars. The other driver was extricated from the vehicle with a compound fracture and serious injuries. But the babies were all good. And I got on the scene when we were taking them out, and outside of the abrasions from the seatbelts, the 2-week-old was facing backwards. I think nothing, So anyways, it works. And anytime we can get this type of information out there, it's going to save lives. There's no question about it. So 31 years in law enforcement, unfortunately, I've been on enough scenes where it didn't happen that way. And it didn't end well. So thank you again. So is there any questions or comments from the committee? Representative Fiddler?
I did have a question. So these are all national standards
Yes.
that are, and what other states have adopted these around us? Are we the lone
Do you
state?
happen- No, we're not the lone state for sure. There's probably a child advocate in every state that's working to keep kids safer when they're in automobiles. At one time, automobile accidents was the leading cause of preventable deaths in children 1 to 14 years of age. And I don't know the exact answer to how many have adopted the
The national.
regulations. Yes. I think there have been quite a few that have adopted some or parts of it. And let me just clarify again, the under 13, the up to 12 years of age in the front seat. I had somebody approach me yesterday and she said, well, my grandchild's 11 years old and he's like 6 feet tall. Surely he fits safely in a front seat. And it's not about fitting into the seat belt. It's about the skeletal structure and formation of children, that the impact of the seat belt is going to do damage to their skeletal frame. So it's about that. Seat belts were created for males 5'10" and 180 pounds. So ladies, every time that seat belt cuts you across the neck in the wrong way, that's why you're not 5'10" and 180 pounds. So, they had to go with something. But when it comes to our kids, back seat, whatever the manufacturer guidelines are for that seat, to max that out, to keep them, as I said, rear facing for up to 2 years, just to protect them and younger children. We've seen reports of children coming out of a seatbelt. If the car's hit incorrectly, they will go through the front windshield. They do that. It creates damage to the soft tissue. I talked with grandparents the last time that Voices worked on child passenger safety. Twin grandsons sitting in the back seat, restrained in exactly the same way. One walked away, and the other one is a C4 quadriplegic. I don't think we want to gamble with our children's lives or their health and safety.
All right, Representative Wadsworth and Representative Jackson.
I'm sorry, I don't have that information, but I'd be glad to get it for you, unless you have it.
All right, Representative Jackson.
Thank you, Mr. Chairman. I want to applaud your efforts, Voices for Alabama Children. Here we are in a state which don't accept help that will save lives, that will protect. We don't have a vision. We don't see beyond what is. We don't like rules and regulations, and that's why we're in the mess we're in. But I applaud you and your organization for doing what you're doing, because protecting children is most vulnerable, because that's the future of the state and nation. So if we can protect them from being injured while they're young, they have a fruitful, productive life as an adult, we've done something and I applaud that. Thank you so much.
Thank you.
That brings us to House Bill 265. I'm sorry, Representative Pettis. Just one more minute.
I guess I got one question. I was a state interpreter 25 years, and on page 5, section 2 says the charges may be dismissed by the trial judge hearing the case, and no court cost shall be assessed upon proof of acquisition of appropriate child passenger restraint. Them not having a car seat's not the problem. They have car seats in there, they just don't put them in it. So this is basically giving them a way out. If we're
Hold on. That's going to be a question for the
Okay.
sponsor. We'll get
Okay.
let's get the bill up first.
We were just here
You're
to
good.
inform.
You're good. So let's do this. Let's get the bill before us, and that's House Bill 265.
Yes, thank
Representative Bolton.
Thank you, Mr. Chairman. And I'd also like to thank Ms. Mann, Dr. Smolla, Dr. Davidson for joining us here and helping us cover our updates to what would be known as the Child Safety Restraint Seat Law. You should all have a copy of the original bill from HB 265, and I have amendments to offer to that, which is going to answer one of the questions that was posed there and several other things. What we've done, we've worked on this several months with everybody that we could get involved that was an advocate and a specialist in this area. The actual idea for the bill was birthed by a next door neighbor of mine, Dr. Sean Cecil. He's with the Academy of the Alabama Academy of Pediatrics Board with some of the doctors here. And we decided several months ago we'd start working on it, and I happen to have a couple of friends that are statewide instructors for the child safety seats, and they had all the resources and everything. So we've gone through a handful of iterations to make certain that we got a good working model that seemed like it was going to work for everyone. One of the things that we did across the course of drafting this bill, I had occasion to speak with Ronnie Anderson down at Dothan PD. He's a traffic officer, and Ronnie had worked a fatality accident with a child that was not restrained, and when he ran the parents' driver's history, he found that she had had 7 tickets for not restraining her children. And so he came to us and he said, what can we do about the penalties? And that's where we took on addressing the penalties too. I worked with Representative England and Representative Daniels, Representative Hall, to make sure that I was good in line with across party lines with updating these penalty recommendations. And what the amendment will do, this was actually an error that we caught when it was drafted. One things that the amendment will do is it will limit the dismissal of the ticket to only the first event. That's the only one that they could do. And in other things, what we've done is we replaced a lot of the things during our negotiations with everyone. We replaced some of the weight limits. And
Representative Bolton, let's I guess quickly go over the bill, and then we'll
Sure.
bring the amendments
Then we'll
one at a
bring them in.
time before
Okay,
us,
that's
and then we'll vote on those.
yes, but what the bill does is it changes the structure of the bill that we have now and ups the weights of the children, as many of the child safety seats over the years have had to accelerate the weights of the children that are permitted to be in the seat, and it also addresses the question about the children up to 13 or under 13 years old being in the front seat. But what we did is, in agreement with Leo's, we went into this bill here and made it only a recommendation instead of a requirement. And that can be a best practice recommendation, and it will just be that the law enforcement personnel will simply have to be educated that it's simply a recommendation. The seat variances, we changed.
Let's do this. Let's go to the amendments then, since we all know what the bill's doing. Let's bring up You can offer the amendments, correct?
Yes, sir.
So let's start with replacing 15 on page 1, and we'll take each one up. We'll
Sure.
take, so this 2-page encompasses all the
That's
amendments?
correct. Yes, sir, that's all the
Let's
amendments.
just start from the top, and we'll do the whole 2 pages, and if there's any questions from the committee, then we'll take up the amendment.
Yes, sir, thank you. Line 15, we changed it to or 35 pounds in weight, age, we changed that one line to say age or 35 pounds in weight, and that was changed to accommodate the seats that are now on the market, although we did find a couple of 22-pound limitation infant seats still on the market and still being sold, so we've got on further down, you'll see an amendment that encompasses all that. We did change that. Also on lines 77 and 78,
Did we do remove lines 24 through 26 on page 1?
I'm sorry, I did remove it. And yes, and I removed that, and that dealt with the bill would prohibit a child under 13 years of age from sitting in the front seat. And we struck that out because we're not actually prohibiting, we're recommending.
Okay. And that brings us to replace line
That brings
77.
77 and 78. And that we struck that because Section 32.5B.4 that is referenced in the initial law that we were amending does not address anything related to child seats. It's a seatbelt law. So what we did, we struck that. And then moving forward on line 81, we increased that weight from 22 pounds to 35 pounds in weight. And we went on, and this is the statement that Dr. Cecil recommended for us, and everybody came into agreement on it, and we changed it from just saying 2 years of age or 22 pounds to say 2 years of age or 35 pounds in weight in the event that the child is less than 2 years of age, weighs more than the recommended weight rating for the infant seat, but less than 35 pounds, a convertible seat must be used. And we came to an agreement on that change there. Also, we changed line 84 further down the page from 40 pounds to 65 pounds in weight. All of these changes dealing with the weight are based on the NHTSA recommendations and also the current instructional materials that are out that are being taught to parents around the state and around the nation. On the back of that page there, on the second page of the amendments, we replaced lines 100 to 104, and that's where we changed it from requirements for the front seat for the child under 13 to simply a recommendation or a best practice. And that way, the parents will know that they should, but there were several exceptions that's provided below there regarding, on the original bill regarding exceptions to putting the child in the front seat. So we felt like it'd just be a recommendation rather than trying to police up all those exceptions that we have. And the last amendment is the one that I was discussing regarding the charges being dismissed. And on line 129, we edited that to read that it could only be dismissed upon the first violation. And when we did our penalties, we included the requirement that all violations, all drivers charged with violation must appear in court. And then we also increased the fine structure, but we put the point assignment on the driver's license record at the same level where it was.
Okay. So the amendments are before us. Is there any questions from the members of the committee on the amendments? Okay. Got the move for favorable adoption of the amendments by Representative Jackson. All in favor? All right, so the bill is now before us as amended. Any questions on the bill as amended? Representative Wadsworth.
Yes, that's a recommendation only, yes, sir. That we changed it.
I'll entertain a motion for favorable report by Representative Jackson. All in favor as the bill as amended for favorable report indicate by saying aye.
Aye.
All opposed? Ayes have it.
Thank
Your
you,
bill
Mr.
has
Chairman.
a
Thank you.
favorable report. Thank you for being here today. right, that brings us to the next bill, which will be Senate Bill 7, by Senator Elliott.
Good morning, Mr. Chairman, committee. Thank you so much for having me this morning. Mr. Chairman, you and I have had a discussion about the disposition of this bill, and what I'd like to do is just talk about it for a minute real quick and then answer any questions. And we've got some things to work out on it, and so we'll have an opportunity to do that before moving the bill forward. But the goal of the bill is introduced was to allow local law enforcement agencies to contract with private schools to provide school resource officers and to absorb the entire cost of that service, that the private schools would absorb the entire cost of that service. And so that we were providing the same level of protection at private schools that we are in many of our public schools. Some concerns came from the County Commission Association about both insurance for those school resource officers and also coverage at primarily at our public schools first, prior to providing service to private schools. So we offered what ended up being a substitute on the floor, which my colleague here in the front row was kind enough to let me do on the floor. And so what the substitute did was say, okay, listen, you got to have insurance that covers these SROs, and then you have to make sure you're covering every single public school in the jurisdiction prior to covering private schools. Well, when I discussed that with my sheriff and looked around my county in Baldwin, we are in an enviable position where we are providing coverage at every single school in the county. So that's all municipal jurisdictions, all municipal districts, and the county as well. That's not the case across the state. And so I am in the position where folks like my bill, and they want to be able to participate in the program, but they're running into some structural challenges when they apply it to their particular municipality or county where they don't have full coverage. And so you may have a situation where the county provides some coverage at schools that exist in the county, but the municipality may not provide coverage at schools that are within the municipality. And the way the bill is structured right now, that would preclude the sheriff's office, for instance, or another municipality for providing school resource officer coverage at a particular singular private school. And so we've got some work to do on this, Mr. Chairman. We want to make this applicable to as much of the state as possible so that our county and municipal friends across the state can use it. And so my end goal here is to carry this bill over while we'll continue to work on that and try to figure that out. And I'll be happy to answer any questions you may have.
Representative Betzel.
Yes, sir, Mr. Chairman. I just wanted to speak real quick. Senator Elliott and I have had really good conversations about this bill. I really appreciate the spirit in which we're trying to bring this to solve some issues. But I just want to say before the committee, you and I are dialoguing about this, and I did bring some concerns to you relative to the term jurisdiction. So just to say to you in front of the committee, we're going to continue to dialogue, and so my pledge will be to you that I'll work with our chairman to bring this bill back up, but I want to continue to have those conversations with you.
Thank you. I appreciate it. And we will continue to have those conversations. And the good news is, as y'all are all aware, sometimes you don't know about these things until you bring them up, and then they pop up, and we deal with them as they come.
Representative Jackson.
Senator, thank you for reaching out to citizens. Is there an additional cost or liability to the reason why we hadn't gotten to a conclusion here?
Representative Jackson, that's a good question. So just to make sure I'm answering your question thoroughly, there are two costs associated with this, right? One is obviously the cost of the law enforcement officer, okay? And in the original bill and certainly in the bill as substituted, that cost is borne entirely by the private school that is requesting the service. Okay. So the good news is you're getting another fully accredited, APOS certified law enforcement officer on the books, and the cost is being paid by the private school. That's a good thing, right? So the other side of this, and what was added into the substitute, is that there has to be insurance coverage provided by the private school that covers that school resource officer. I think it's fair to say the County Commission Association was concerned about increased liability associated with this additional person on a private school campus. And so that cost too in the bill as substituted would have to be borne by the private institution.
Thank you so much.
Thank you, sir.
Representative England?
Thank you. Just real quick, I know that when you're a sheriff, operating within the line and scope of your official capacity, you carry a certain amount of immunity with you. I'm interested to know if contractually, if that sheriff's deputy enters into a private contract with a private school to provide SRO services, does that immunity get abrogated in that situation, or does it continue to follow him as long as he's wearing a uniform and he's operating as a sheriff's deputy?
Representative England, as usual, that's a very good question. And so I think that the answer to that would be yes.
Yes.
They're still a law enforcement officer. They're still operating as a law enforcement officer in their jurisdiction. And so, the benefit that I was just speaking about with Representative Jackson was you're getting an extra law enforcement officer that's paid for by somebody else. But yes, I would expect that they would continue to enjoy the same immunity that other law enforcement officers would have. There would be an added, as the bill is substituted, there would be an added layer of coverage from an insurance standpoint, but that's not your question. Your question is about immunity, and I think the answer to your question is yes, these folks would still enjoy that same immunity.
Well, the reason because often officers are contracted out. They wear uniforms, but they work for private businesses. Like they may go to Walmart or something like that. And I just don't remember if we structure those contractual arrangements that also reflect or recognize that immunity or not. And also, I believe that we have a special statute that authorizes SROs. And I wonder if we would also need to amend that to include the ability to contract law enforcement out to private services as a function of SRO to kind of extend that protection.
That's a good point too, and we can look at that statute. I want to go back to the immunity thing for just a second. And again, I think it's important to note these are not, the contract is to reimburse for the cost of. So you're not hiring an SRO for your private school. The sheriff's office is assigning an SRO to your private school and you're paying for it. Do you understand the distinction? Do you see the distinction there?
Practically yes, functionally no.
Okay,
because they're still doing the same.
Oh yeah, no question.
Thing.
Yeah.
And the responsibility doesn't necessarily change because I'm thinking that as long as you're in uniform and you're still operating within the line and scope of your duty, regardless of who is paying you, I don't know if that changes the immunity or not. And that's something, and which is why I think it would help protect that officer if we actually not only created this code section, but maybe amended the SRO code section to say, this is also an authorized practice. Because, they're doing the same thing. They're providing the same services to a private entity. But when you provide services to a private entity at a cost, then you are also implying additional liability there because, again, you're working pursuant to somewhat to their directive, more so than you are to the sheriff. Because, something else could happen on a private school campus that you may, they may direct you to do something without, you could create some conflict. And it's not that it would happen often, but the potential is there, which is why maybe we would also be better serve the interest of the state if we amended the SRO code section to say that this is an authorized practice as well for this purpose.
It's a good point. We'll look at that because you brought up a number of questions in those comments that I looked at and went, no, we need to make sure that it's clear. This is under the direction of the law enforcement official. This is not outside their chain of command. These folks are operating as a law enforcement officer inside their chain of command. Again, the reimbursement is just occurring by the private schools, but these are not folks that, in my mind, are under the direction of the private school. or any authority of the private school, and that these law enforcement officers will be, fully accredited, fully sworn officers that are acting, as a law enforcement officer. The only caveat here is they may have some additional insurance, and they may be that their cost may be reimbursed somewhere else. But welcome to the conversation, and I intend to pull you in on it, sir. Sorry, you get some good
But
questions.
you're correct, and your questions are valid. But what we do, as long as they're working in a line and scope of their duties, we've had folks at these private schools. Can you help us clean up, get these tables put up? We shut down. No, we can't do that.
Yeah.
You have to be working in that line and scope. The immunity follows with you when you're acting in the line and scope of a law enforcement officer. You're falling under the umbrella of your department rules and regulations and policies and state law. So it does, because we all over the city of Birmingham, we're working in all kinds of capacities, private. And yes, and then we carry additional insurance. I don't know if everybody in the state does that, but the liability does follow. So, any other questions? So what we're going to do we'll carry it over to call it a chair. Sponsor is agreeable with that.
Absolutely.
So we'll work on it, and hopefully we'll get some things ironed out and bring it back up.
Mr. Chairman, members, thanks for the opportunity to come down so quick and talk about it, and for y'all's willingness to help me figure some of these fun issues out.
Well, I'm glad you came, because we got Senate Bill 105 and Senator Singleton, and we wanted to just show you up in the upper chamber how well we treat you folks up there.
Well, you better treat him nice, because I'm the easy one of the two.
Reciprocal.
There we go. Get him, Jackson. All right, Senator Singleton, Senate Bill 105 is now before us.
Thank you, Mr. Chairman, and thank you, committee, for allowing me to come here today. This is what I think is a simple bill. This bill has been engrossed. There is a group that's called the Community Certified Community Emergency Response Team, initially called CERT. In my area, I get a lot of tornadoes in the area, and FEMA has come in and asked us to set up these CERT groups. And CERT groups are groups that go out as first responders do to help with search and research. With search and rescue, also setting up FEMA staging, making sure that families are getting taken care of on the day or the night of the storm, the days after, and making sure those CERT teams are in place. And so there was an immunity that is given to them, as we do with our volunteer fire departments or any other first responder. The Trial Lawyers Association saw that immunity because it was basically training was set just for the state and or local EMAs. And so what we're requiring now that they be trained by FEMA, and if based on that, they was okay with that immunity being given as long as they got the adequate FEMA training. So this is just another a team that can be out there on the ground helping with search and rescue and organizing families and getting families together after storms and fires and whatever happened with the emergencies. So with that, I'll entertain any questions.
All right, Representative Jackson and Representative Wadsworth.
Thank you, Mr. Chairman. I just want to commend the senator for looking at the vision, looking ahead, protecting and saving lives as much as possible. And this certification is going to really speed up the process of life saving. See, in a tornado line zone, where we all Southwest Alabama, they're tremendously and they're devastating. They're becoming more frequent than ever before, more powerful. And so it's only fair to us that FEMA come in as quick as possible, do their due diligence, and we have training people to go out and search and rescue those who have been injured and displaced. Thank you so much for bringing this res.
And these groups also allow FEMA to be able to run supplies or whatever, groups to coordinate those things on the ground. Because a lot of times when FEMA come in, they be trying to identify with certain nonprofit groups to be able to run. These are groups that have been trained and certified by FEMA. They know exactly who's on the ground and who to run their supply.
Thank you so much.
Yes.
So we have a motion on the floor. If there's no other questions.
Oh, you are? Great. Thank you. So am I.
All All right, we got a motion for favorable report by Representative Wadsworth. All in favor indicate by saying aye.
Aye.
All opposed, your bill has a favorable report.
Thank you, Mr. Chairman. Thank you, committee.
And that brings us to House Bill 241, Representative Laverne. Already got a question.
Thank you, Mr. Chairman.
Mr.
Members-
Chairman, I move we carry this over until we can have a conversation with the chairman of the rules.
Denied. Go ahead and explain your bill.
Thank you, Mr. Chairman, for that support there. HB 241 is a Roadway Responders Act, and we have many former and current first responders in this group. One thing that was found in state law is the second you step out of your vehicle, you become a pedestrian. And under Alabama law, a pedestrian is any individual afoot. So when you step out of that vehicle, you're abandoning some of that authority on a roadway when it comes to being able to close a roadway at a vehicle accident or some other incident where you may need to alter the traffic flow. And what this bill will do will help clarify any pedestrian upon a roadway shall yield the right-of-way to all vehicles upon the roadway under current law. And this will exempt first responders from the requirement to yield the right-of-way and clarify that they are not pedestrians when performing defined actions in their official capacity. So if they're responding to that scene, acting accordingly for the safety of the people on scene, they are not merely a person afoot. They are still working under their capacity under law enforcement or for any other first responder.
Y'all heard the bill. Representative Jackson?
Thank you, Mr. Chair. I just want to ask, bringing this sponsor, like this morning coming in, there was 2 accidents on 85. So what do we do? Wait on a responder or get out and try to help someone?
Well, I think you.
Since we step out of our vehicle, we become a pedestrian instead of acting in a capacity trying to help.
Well, you are a concerned citizen that are assisting and helping, and I would certainly assist people to try to stay safe and make people that you're trying to assist there as safe as possible. The points of this law would just direct to those responding as first responders. Okay. You fall under a lot of Good Samaritan legal help. This is for the first responders working in that capacity to maintain their authority to shut down or alter traffic as needed to help maintain that same
Great
safety.
bill. I appreciate it. Thank you so much. But I just questioned about, because this morning it was a mess.
Thanks for your question.
All right, no more questions. I entertain a motion for favorable report. A motion for favorable report, Representative Jackson. All in favor indicate by saying aye.
Aye.
All opposed? Ayes have it. Your bill has a favorable report. Thank you.
Thank you, Mr. Chairman, members of the committee.
That brings us to our last bill of the day. That's House Bill 44 by Representative England. That was to keep a quorum. Yes.
Everybody running out of here? I don't know. This
I
whole
find
thing has changed.
this is strange with your attendance record at this committee, so that you would even bring it up.
What are you talking about? I've been here just about every day. Thank you. This is House Bill 44, and it seeks to create 2 things. First, list certain information that will be elicited from incarcerated citizens that they provide with those who are incarcerating them in the event that they get injured or seriously injured or they die. Who's to be notified? Also, information such as directives in the event that death does occur, to instruct those individuals what to do in the event that happens. And then also creates notification requirements in the event that someone suffers from a serious physical injury, which is defined, or serious medical condition, which is defined in the bill, when whoever they designate as their emergency contact should be notified. And that's essentially what the bill does. I have an amendment from the County Commissions Association that also gives a little bit more time for the incarcerating agency to elicit that information from whoever's been who's ever was in their custody. So
Let's go ahead and explain the amendment, and then we'll get the bill before us as amended, and then we'll ask questions.
all right, if you go to page 1, lines 20 through 22, and you replace those with the following: agencies to provide an opportunity for each detained individual the agency holds in custody to provide certain information to be included in the individual's custodial record and to require custodial agencies to notify A. And then on page 2, replace lines 49 through 51 with, to the extent practicable, shall ensure that each detained individual it holds in custody shall be given, within 48 hours of being taken into custody by the agency, the opportunity to provide all of the following information to be included in his or her custodial record. And that shifts the burden to the person who's incarcerated to provide that information.
All right, any questions from the committee on the amendments? All right,
Yes, the amendment, yeah. And
we got a motion to adopt the amendments by
So-
Representative Jackson. No questions? All right, all in favor of adopting the amendments, indicate by saying aye.
aye.
All opposed? Okay, now the bill's before us as amended. Do we have any questions from the committee? We got Representative Jackson, Pettis, and Bedsole.
Thank you, Mr. Chairman. Mr. Engler, I want to applaud you. Could you tell some of our committee members why we have this situation, why your bill is so important?
Well, I'll start. I know you've probably seen the hundreds of emails that have gone
Yes.
out, and there's oftentimes a disconnect between incarcerating agencies and the families of those that are incarcerated. So what this bill is trying to do is to, fill that void with creating a duty on the incarcerated to provide information of contact, what to do in the event I die, but also creating a responsibility on the incarcerating agency to notify someone in your family if you've died, which we've had an issue in the Department of Corrections with that recently. A couple of situations specifically where the family didn't find out that their whoever loved one was died until they were buried. So this would create a responsibility on the Department of Corrections to let you know within a certain time frame that that the person, your loved one, has died, which I thought was just kind of basic. But also, when you have a serious medical condition, you list out the person or the persons that you want to be contacted in an emergency situation, and it creates a responsibility on that agency in the event that you satisfy the circumstances listed in the bill that they have to notify you.
Thank you so
that's-
much.
that's
Thank you.
All right, Representative Pettis?
My question is, what if they don't?
But they don't.
Yeah, what if they don't? There's no penalty. I passed bills in here said they will do this. If they don't do it, what?
Well, see, and that's a great question because oftentimes we will pass a law that creates a responsibility on a state agency, and we hope that they follow the law. But when they don't, we generally end up back here later on adding criminal penalties to the legislation like this in order to gain compliance. But our hope is that putting this on the books creates the responsibility on incarcerating agencies or correctional facilities to establish a protocol. So when these things happen, this is the basic bare minimum, but they could do more if they want. But this is really just a basic bare minimum qualification or standard just to notify somebody that they authorize to have their personal information. So in the event something happens, they know about it. But if in the event they don't, which is not rare in state government, then we'll have to come back and explore, maybe adding additional incentive.
Representative Bedsole and then Representative Wadsworth.
Thank you, Mr. Chair. So just a few quick things I was hoping you and I would have a chance before. So certainly being someone that has been in the business of running a county jail. So first, I think I heard the spirit and intent of this. So before I get too deep, would there be any possibility that we limit this to not include our county jails? But the problem seems to be with the state level. I don't see any of the DOC officials here. I hate to throw them under the bus, but the issue I hear you presenting has to do with our State Department of Corrections. And so would there be, a possibility that we could really focus this bill on into where the intent should be?
Well, I mean, certainly we could talk about that, but just talking to individuals across the state, there's no basic bare minimum standard. So you have some correctional facilities, local facilities that have issues with notifying individuals in a timely fashion of death or serious physical injury. It happens. So not to change anything that somebody's doing, but to kind of provide some sort of framework or a minimum standard across the board would help. So we have a standard across anybody who's incarcerating individuals. And I mean, we've had some pretty harrowing incidents that happened in county jails. I mean, incident occurred in Walker County. So I think just creating a standard that we all must abide by, I think it's a good idea.
So, I don't disagree with you. I think sometimes, and this is one of those as a professional, from my professional point of view, that this is a policy type issue, and this is not something that I think should be necessarily embedded in law, because I can understand the spirit, and I can also agree that communication with the family can be very helpful. But from a practical standpoint and functionality, and I'll just give you a very small example that some of these pieces, we talk about putting them into the central file of the inmate. As you well know, like most all facilities now are digital, and their central files aren't necessarily paper. But the jail management software doesn't necessarily allow for things to be captured that you're saying has to be captured here. So, for example, the facility in Shelby County, we have name and phone number, the bare minimum that is captured. Now, oftentimes, and I'm appreciative of the amendment because it says it's telling the inmate that it provides an opportunity for them to give it, not necessarily that you have to, because oftentimes what we find is they don't want to give us information of anyone. So we run into a position quite often where I will go look for the emergency contact and there's nothing there because they didn't want to give us one or failed to provide it. So some of the things here that are being asked of, I don't know that all jail management software. So then are we going to say collect a file outside of the file that would be more paper in nature so we can satisfy the requirements of the law? But bigger issues to me is a couple areas. Serious medical condition, the definition of serious medical condition, and a couple of those points there. So, for example, I'll start with letter A there under serious medical condition. That is quite obvious one, and I think I could agree, and everyone would. Letter B, admission to the hospital is required. So some of my concerns there is again, professionally speaking, sometimes there are procedures that cannot be accomplished inside the jail to offer that inmate the necessary level of medical care that we deem that we think we should in adherence with the law, but also in our standards that we held personally to Shelby County. Sometimes those procedures have to be done inside the hospital, and that requires an admission. But that doesn't mean that this is some kind of imminent life or death type situation. So we would be sending them to the hospital for admission, and then we would be required by the bill to then turn around and call the family and tell them, and probably alarm them beyond the extent that is needed that they're going to the hospital for a medical procedure. But by doing that, then it leads to my next 2 points. First is I think we would be treading in an area of a HIPAA violation and possibly having some issues with federal law related to us communicating a medical issue or condition to a family that is not the individual or the person. And then the next thing is to our law enforcement officers that conduct the transport and that would be sitting with the individual inside the hospital. Family member would be notified that they're at that hospital, and then they would quite possibly respond, and it creates a very dangerous and oftentimes can be a very stressful situation with family wanting to see that individual. And then I'll add as an aside, most hospitals, when we do transports, they don't even list the individual's name on their board because they try to avoid those circumstances. They don't want families showing up. They don't want disagreements in the hallway. So the hospital would then put them in a situation where they're having issues with the family. And honestly, I wouldn't want it to be where the family gets into an issue with law enforcement. So just trying to avoid those things. And so, all in all, I mean, I completely do. And trust me, I understand what we're trying to accomplish. I think these are matters of best practice. If we wanted to go through and create state standards for jails and prisons in our state, that's a whole nother issue. But these would be great guiding principles for state standards. But I just really feel like for a piece of legislation, there's a couple issues here that just give me some concern.
Yeah, just to address a few of those. The first, as far as HIPAA violation is concerned, you can authorize, the individual can authorize a person to share with a specific person, as long as it's next of kin, medical information. It's just like when you go to a doctor's office and you sign a form, who can I give this information to? You sign it, you've authorized husband, wife, brother, sister, whoever. So that will take care of the HIPAA issue, because the inmate at that point would be designating a next of kin to receive the medical information. As far as the other issue you've talked about, and I do, it makes sense. The thing I'll say to that, though, is that this is actually federal. We got these standards from the federal law. So this is what they do now. So they do, in the event somebody goes to the hospital, they notify the next of kin. And, the standard of determining whether or not this particular ailment rises to the level of notifying a family member, I mean, it's going to be different for everybody involved. So that's why I'm just trying to create a basic minimum standard. And as far as like the information and the records that law enforcement keeps, and the fact that sometimes the state passes a law that would require you to do a little bit more record keeping, that's something that we do quite often. We've done it on several occasions with traffic offenses and requiring demographic information to be kept on traffic offenses, or adding additional offenses and so forth, because, we do, for whatever's worth, we do set certain basic minimum standards for law enforcement and responses by some of the codes that we set. We also control how things are billed, how permits are given, and so forth. So we do create policy through law for government agencies to follow. And this is just another example of that.
But, in some of these areas here, and I'm sorry I failed, but you're asking the jail officials to tell the family if the individual has been diagnosed with a terminal illness. I mean, don't we think we're stepping into a territory in which the healthcare provider, that should be something that they're able to educatedly speak to the family and say, your loved one is being diagnosed with a terminal illness, and we're asking our corrections officials across the state to kind of step into the medical role there?
We're not. It's the exact opposite in the event, because the law enforcement officer wouldn't be diagnosing anybody with a terminal illness. What would happen is, if somebody had a terminal illness that led to them either having to go to the hospital or, in fact, being close to death, we're creating a responsibility for whoever's incarcerating this individual will tell their family. So it's not like we're telling them to diagnose anything. We're saying that if you're diagnosed with a terminal illness, which unfortunately we have run into on several occasions with our Department of Corrections, where we found out that somebody actually was diagnosed with terminal illness, was being treated for it, and eventually died as a result of that, and they never notified the family until after it happened. So again, Department of Corrections did come up again, as you said, but for this bill in particular, it's just trying to establish a basic minimum standard for all corrections facilities. So just a basic level of care and concern for the families of those who are incarcerated.
And I'm not tone deaf to that. I understand, and it's certainly a standard. Each facility has to know the appropriate level. But I just think some of these, and again, here's another, they shall tell the family the cause and nature of the condition. If they have a serious medical condition, the custodial agency shall notify the next of kin of the cause and nature of the condition. I think I would be concerned there as someone who was running a facility, that I had my jail deputies communicating with the family the cause and nature of a condition, that they don't have the medical necessarily background to adequately describe that. So I just think it puts them in a position where they are stepping into a little bit of the medical arena.
Well, no, I mean, usually what would occur, because I know what we do here, is we have somebody that's kind of designated to communicate that information to the family. It's not just every corrections officer there. And again, it's just so a basic level of information is given to the family, just very basic.
Thank you, Mr. Chair.
Okay, thank you. And I talked to you earlier, Representative England, about my concerns on the safety, and Representative Betso had mentioned some of that at the hospital. My concern would be, and you're willing to entertain an amendment that
Yeah,
would
sure.
address that as far as if we're looking at a high-risk inmate, or someone very violent, or someone we're concerned that maybe a gang member wants to find out where they're at and come up to that hospital, where it's not, we've got them out of a secured environment. So there's got to be some flexibility built in on that type of notification when that situation is deemed secured. No, we're going to work on that, right?
Oh, yeah, absolutely.
Okay.
Yeah, of course.
Any other questions from members of the committee? Representative Wadsworth and Representative Jackson.
The only question I had was, I know on page 2, it says that the custodial record, they have to make a determination of whether or not they got a medical power of attorney, advance directive in those provisions. If they don't have that information, is there any requirement that the state provide that to them, or is that something? Okay.
No. No, just if you have one, you have the opportunity to give it.
But it's not to be provided by the state?
No.
Okay. That's all.
Yeah.
He's trying to answer them. Okay, Representative Jackson and Representative Starnes. All right, at the proper time, we got Representative Starnes.
Hey, Chris,
Yeah.
I'm seeing on the physical note, the bill would increase the obligations to the Bureau of Pardons and Parole by $100,000. Why is that?
Because that kind of surprised me. But I mean, maybe involving them in notification. I mean, I'm not sure.
Okay.
Yeah, that kind of caught me off guard.
Okay, yes.
Okay, got a motion for favorable report by Representative Jackson. All in favor indicate by saying aye. Aye. All opposed, same. All right, ayes have it. Your bill has a favorable report. Entertain a motion to adjourn. A motion to adjourn by Representative Jackson. All in favor indicate by saying aye. Aye. Opposed, ayes have it. We are adjourned.
Great day, great day, great day. You know they got enough police officers. All y'all in there. I don't know why they got educators in here with you guys. First responders and stuff.
I don't know. It is a weird mindset. You see a lot. You witness a lot.
Y'all seeing it from that physical. I'm looking from the spiritual side.
Yeah, but my concern is I got a gangbanger in there.
You ain't gonna post it.
No, but
You don't say.